healthcare special as a form of redistribution or as a form of solidarity between members in a society. And one of the things, one of the primary theses of this paper is that there is a right to adequate health care. And it can be defined operationally, which is a real challenge for scholars and policymakers in this area. It's the right to access, to equal access to that middle-class health care, to the sort of health care that is available to those in the middle of society. But Professor Elhaig realizes that we could today easily spend 100% of our GNP on health care without running out of services that would provide some positive health benefit to some patient. So thus, trade-offs must be made, and thus the moral principle that we owe health care to each other, or that we can move that amount of health care provided to the middle class, is not in fact absolute. It has to be traded off. Both within health care, we have to trade off on which priorities for spending given a limited budget, but also we have to trade off between healthcare and other consumption decisions to decide how much of a healthcare budget we want to have, given that there are other values in life. And Professor Elhaig says in this paper again, we could accept the proposition that the greatest good in life is health. So put everything else secondary, but still conclude that purchasing more health care is less effective than funding nutritious food, safe housing, environmental protection, college tuition, or even simply distributing cash. And in 1994, there was already a really clear empirical basis for this theory called the social determinants of health. The idea that our health outcomes are determined more by the lifestyles we live, the neighborhoods we live in, the security we enjoy, the diets we consume, that our health is more often and larger determined by those factors than it is by the health care we receive itself. And that evidence has just gotten stronger and clearer in the 20 years since this paper. It has been 20 years, Professor Elhaig. This is supposed to be a roast, right? And I'm not just going to read from Professor Elhaig's papers all day, but this is one more passage. He says, we value many things besides health. The cost of devoting resources to healthcare is often expressed monetarily in those graphs I started with. But that's merely a shorthand for the value we could derive from alternative uses of those resources. It makes no sense to spend money to live longer at the sacrifice of those things that make life worth living. In the end, we all die. The question is which allocation of resources will allow the best things of life. I think this reflects some of the best of Professor Elhaig's scholarly instincts, moving between rather technical analyses that you'll see throughout this paper and others into the details of antitrust law, but also remaining sort of philosophically ambitious and philosophically grounded to pay attention to what's really at stake. So when we think about that growth of health spending as a part of the larger economy, we know that the bulk of the long-term rise has resulted from the healthcare system's use of new medical services that were made possible by technological advances. Here we're talking about drugs, devices, imaging, other tests that are really driving healthcare growth. We know all about the demographic changes, such as the baby boomers getting older, but they're not the explanation for that consistent growth for the last 50 years that's predicted to go forward. So they create the bumps along the way, but the sort of inexorable drive to more healthcare spending, most analysts understood, is largely driven by these technological advances. And when you think about technological advances, that is driven by our patent system, our antitrust system, and the incentives we create elsewhere in the healthcare economy. But strikingly, when you look at what is actually consumed in this system, less than half of it can we say that we have evidence that it actually works, that it actually makes us at all healthier. That's a pretty low bar to cross, because conceptually, the proof that it makes us at all healthier. You might want to set a higher bar that says that it makes us more healthy than the next best alternative, or it makes us next best healthcare alternative, or that it makes us more healthy than anything else we could do with the money and these social determinants. But here, even in the low bar of any proof that it works at all, for most healthcare spending, we just don't know. And so that really compels questions about how we can regulate in this area to make the healthcare spending more efficient. And so that brings me to this 1996 paper of Professor Elhaeg's, where he actually takes that question on directly and says, could we create a regulatory structure that has a specific goal of looking at health technology and deciding whether it should be allowed on the market? Or they might have other more precise levers, whether it should be reimbursed by Medicare, or whether it should be allowed in certain clinical settings. But the most fundamental threshold question is whether it should be allowed on the market at all. So you can imagine a regulator being created with this task. It's not exactly the task the FDA has, by the way. The FDA's statutory mandate is whether something is safe and effective, and it's not whether it's cost effective at all. So Professor Elhaeg's view on this is that he doubts that technology regulation can do much about the cost escalation problem. The technology we get reflects the incentive structures for using it. There's a lot in this paper that explains why it's difficult to do technology assessment. In part, it's because of the heterogeneity of a population. The technology might be good for one patient in one clinical setting, but bad for another patient in another clinical setting. So there's heterogeneity. There's also very deep philosophical problems in trying to figure out how much a year of additional life is worth, and how much is worth for one person compared to another. So these deep and difficult problems have largely been punted in our healthcare reform efforts. We've largely put them off to the market to solve. And the primary way that the market is trying to solve this problem is by asking the patient to do some of that hard work, to do that difficult task of selecting whether healthcare is worth its price, whether healthcare should be consumed. This graph displays the growth in healthcare plans in the employer-sponsored health insurance market, which is most of the health insurance market in the United States. This is the growth. The top line shows all firms. The growth of them having plans with at least a $1,000 deductible. And you can see just from 2006 through 2012, it's more than doubled in the number of firms, going from 16% to 49% that have these higher deductible plans. Now, even $1,000 is a pretty low threshold for deductible health plans. Federal law allows them to be 6 times higher than that. But even below the $1,000 threshold, we're seeing fewer and fewer firms remaining there, which means patients are more and more asked at the point of consumption to take out their wallets and make the decision as to whether a fraction of the cost of that consumption is worthwhile, and if not, to decline to consume. So in a sense, we've pushed out the difficult decisions that Professor Elhaeg prefigured, and more pushed them out into millions of micro-level decisions by individuals deciding whether to consume. And the way cost sharing works is it takes, the cost of a procedure and splits it and says, patient, you have an obligation for some amount. Insurer, I'll pay the rest if you decide to do it. And this is really old-fashioned economic theory, that if we give patients skin in the game, then sometimes they will assess whether the benefits from the consumption will be outweighed by the cost that's imposed on them. And it's important to emphasize that cost sharing really has 2 different functions. One function is the obvious one, that for any health care that is consumed, the insurer just bears a smaller proportion of it. So if it's a $10,000 procedure and you can make the patient pay $1,000, then from the insurer's point of view, it's now only a $9,000 procedure. They've saved on the margin whenever health care is consumed. But the second effect here on the right is actually to change how much health care is consumed and which health care is consumed. I call the first one a distributional effect. It distributes the cost between the insurer and the patient. The second one's a behavioral effect. It's designed to change which healthcare is consumed and how much. And so the idea is that of 9 instances of healthcare consumption, we actually try to make 3 of them disappear, for example, because the patient realizes that, gosh, maybe that cost share isn't worth the price. Maybe I'll move to a less expensive form of care or other mechanisms. Now, there are limits to cost sharing as a rationing mechanism. And the big one comes from our recognition that most of health insurance, most of health consumption is actually consumed at the very top by a very small number of people that are consuming very large amounts in a given year. These are people that have chronic illnesses. These are people that have other severe illnesses like cancer or need heart stents replaced, implanted. So 5% of our population in the United States is consuming half of all our health care in a given year. And they're spending on average about $55,000 in that year. Not out of pocket, that's the total spending for that patient. And so when you think about how cost sharing is going to work in this domain when we're in these high dollar figures, if we really want to sort of reduce health consumption, we have to be thinking about how it works in this high-end range where most health dollars are actually spent. And I think that's something that's often overlooked by policymakers in this area. So the other difficulty with cost sharing is that in fact we have to cap how much exposure an individual has. Because individuals have limited wealth. And we can't, insurance will fail to serve its purpose of guaranteeing access to care and protection from risk if patients are have so little insurance that when they approach a big healthcare decision, they're unable to access the care they want. We then have a problem of false negatives, where individuals decline very good, high-value healthcare simply because they can't afford to meet the out-of-pocket obligations. So accordingly, health insurance beneficiaries and their agents, which are often employers, will provide health insurance plans that cap their out-of-pocket obligations. And this is from a survey of all employer-sponsored health insurers, a sample of them in the United States. What you can see is in 59% of the workplaces, the employee is exposed to less than $3,000 of out-of-pocket spending in a year. So that's their first deductible usually, which is often about $1,000, and then it's 20% of the consumption up to that, beyond that first $1,000 until you reach a $3,000 total. So for 59% of the people, once they've spent $3,000, they're back in a realm of full insurance. They have no cost-sharing obligations at all. And you can see even above that, only 11% of the population is in truly higher deductible health plans at $5,000 or more. So for an example of how this works, if we want to really understand what cost sharing does, you have to think about it in practice. And this is how you would reach that $3,000 deductible. First, at the beginning of the year, you would have tests and preliminary procedures and perhaps a visit to the hospital, and it would exhaust your $1,000 deductible. In that deductible range, you enjoy no insurance at all, really. You have 100% skin in the game. But in the next range, you have some insurance, this range where you're paying 20% of, or 18% is the most common copay, of the health care consumption. So that ends up being 18% of the next $11,000 is where you're in this middle range of full insurance. Once you've surpassed that $11,000 of health spending, you reach the $3,000 cap. So that means that health cost sharing as a allocation mechanism, as a rationing mechanism, which originally motivated this analysis, is sort of done for the patients by the time they reach $12,000 in total spending. That's a lot of money, but it also, patients spending less than that are not accounting for most of the money that's spent in the United States health care system. So cost sharing then is so when we think about this $3,000 cap, is that a lot of money or is it not enough money? And this is data from the U.S. Census Bureau for income. I've put the income in the United States in 5 quintiles. I'm sorry if the text is a little small. But you can see in the bottom quintile, these are people earning up to about $20,000 a year. For them, a typical cost-sharing maximum of $3,000 is 30% of their income. On the other hand, if you look at the richest quintile in the United States, that $3,000 of cost-sharing exposure in a year is only 2% of their entire income at the middle of the quintile. In fact, I had to censor this for visual purposes, because if I put the top 5% of American earners, they wouldn't even fit on this graph, of course. So you can see in the middle, for median Americans, that typical cost-sharing maximum of $3,000 is about 6% of their income. So that graph I showed you, the very different relationships between cost sharing and income, has also been seen with surveys of how people actually spend in healthcare. We know the wealthy spend about less than 1% of their income. The people in the top quintile spend less than 1% of their income on out-of-pocket healthcare, while the poorest are spending 11 times as much as a percentage. So that creates two domains for us to think about. And the first domain is those people that are overinsured. The people that have more insurance than they really need in order for insurance to serve its purpose of protecting us from risk, its purpose of guaranteeing our access to care. For these individuals, the cost-sharing obligation is probably too low because they could bear more risk and thus be empowered as rationers in this healthcare system longer for a larger portion of the healthcare consumption decisions. At the same time, there's likely a range of people that are underinsured, those that have too much exposure to risk, and they find themselves in bankruptcies and foreclosures and denying needed care. And so this is a fundamental problem, I think, in our current healthcare system that prevents cost sharing from being a complete solution to the allocated decision making that began our talk. So in the overinsured area, we have this domain of moral hazard, this domain where people are making healthcare consumptions. At the point of consumption, they're deciding whether to take the patented drug rather than the generic, but they don't face that price distinction at all because they enjoy full insurance beyond that range. On the other hand, we have those below that are underinsured that are experiencing bankruptcies. This is a study by Elizabeth Warren and a team that looked at people going through bankruptcies and found that half of them were associated with medical bills or medical injuries. Some of my own, I hit page down instead of next. That's dangerous. In fact, most of these slides I wasn't even planning on showing you. Okay, I'm back. Similarly, for foreclosure, in some of my own research, I surveyed people going through home foreclosure and found that many of them were actually driven by medical problems. So what we know then is that cost sharing is now effective in this green domain. I have patient income on the vertical axis, the cost of the procedure or the treatment on the horizontal axis. And we know cost sharing sort of works for people that are relatively wealthy, but only for the low-cost care, the first $12,000 of care. It doesn't work at all for the very poor people. That's why it doesn't go all the way down to the axis, because they can't really bear much cost at all. Nor does it really work going out to the right for the very highly costly procedures. A heart stent implant that costs $50,000, or a patented cancer drug that costs $80,000. In those domains, cost sharing is really not a very effective solution. So my research has been working on ways to solve this problem, and I've been thinking about two different mechanisms that we could use in sort of future rounds of healthcare reform, or perhaps through market-based solutions right now. And the first one is in this domain. And the idea is to scale cost-sharing obligations to income, so that individuals have the amount of skin in the game that they can bear. And the difficulty, of course, is figuring out how much they can bear, but I suggest that in the employer-sponsored health insurance market, the individual's wages is a pretty good proxy to the amount of risk they can bear. And that information is readily available to the person that buys the insurance for them, their employer. So here's a nice coincidence that we've evolved a healthcare system where the one person in society that knows how much you're paid also is the one that's providing your insurance. Simply transferring that information from one function to the other can provide greater insurance. So that line is diagonal, meaning that as long as you can bear risk with higher income, you can also have cost sharing involved for higher cost procedures. Beyond that line, though, the worry is that if we imposed additional cost sharing on you, if we asked you to pay a $5,000 deductible or a $15,000 deductible, that would deny your access to care and defeat the purpose of health insurance. So in that domain, I've suggested a second possible solution, which is called the split benefit, where we could actually pay health insurance benefits as cash to patients and allow them in that way to decide whether to consume. I'll talk about each of these just for a couple of minutes. The first one is scaled cost sharing. This paper is coming out next year. And the notion I've already suggested is insurance is provided by employers. Employers know how much wages they pay. They can scale cost-sharing obligations accordingly. And so, for example, you might suppose it becomes a 7% out-of-pocket annual maximum. That your employer says, your obligation, I see you make $100,000 a year, then your maximum exposure this year is 7%. But on the other hand, your assistant who makes $50,000 a year, her maximum out-of-pocket exposure is $3,500. On the other hand, the vice president of the company who's making $200,000 a year, his out-of-pocket exposure, her out-of-pocket exposure would be $14,000. So each individual gets a report, as part of their benefits package that scales their cost-sharing obligations to their income. Strikingly, there seems to be no example of a current employer actually doing this in the United States. The closest is one firm, Pitney Bowes, that has a few different tiers where managers seem to have higher cost-sharing obligations than lower-level workers. But that reflects the insight. We do see more often about 10% of employers are scaling insurance premiums to income. And that serves a useful distributional function, but it doesn't solve this behavioral modification function that is cost-sharing. The example here is focused on scaling the maximum out-of-pocket exposure in a given year, but you could also scale deductibles so that maybe people enter that realm leave the realm of no insurance and go into the realm of some insurance later. You could scale their co-pays, so instead of everyone paying 18%, some pay 25%, some pay less, and even the amount you owe at the doctor's office could likewise be scaled. We now have the technology to do this that we maybe didn't even have 15 years ago, so that doctors' offices can consult in real time, an online database for each patient to see what their obligation is. And we already do this for other purposes. So the idea is that this reform would be potentially cost savings on net. It could actually bend that cost curve down by providing more skin in the game in that realm where the most health expenditures occur at the high end. For those expenditures that are, over the $12,000 where the current caps often put people. So we would put more skin in the game for the wealthier employees. You might have noticed that, our distribution of incomes is not linear. That it starts curving up pretty sharply at the distribution of incomes. We have people getting really, really wealthy, but there's kind of a floor on how little you can earn. Zero does that at the very least. And so there's actually more room for scaling upwards than scaling downwards, which suggests that the reform may be asymmetric, that it may save more money than it costs, even if at the same time we're expanding insurance for poorer workers. This also arguably creates a larger bargaining surplus between the employer and the employee. You can imagine if an employer offered pants as an employee benefit. Everyone gets a free pair of pants for working here. Well, if the pants were one size fits all, people would value those pants not very much. But if the pants were scaled so that each person gets the size of pants they need, individuals would value those pants more. They could actually use them. And so the idea is that when you scale a benefit, assuming you can do so with low administrative costs, you can actually get a higher perceived value by the recipients along the entire domain, and thus have a greater bargaining surplus. Because most health insurance is actually understood to be foregone wages. Individuals get health insurance rather than wage compensation. And so the value of that insurance can be more or less attractive. And there's also a lot of evidence that providing greater health insurance could actually increase productivity for lower paid workers, that reduce absenteeism and that sort of thing when people are on the job. How much time do I have? 3 minutes. So there's a lot of potential legal problems that I developed in this paper about the Affordable Care Act actually capping cost sharing, but there's still room, I argue, for scaling underneath that cap. That the tax code actually, by making health insurance non-taxable, discourages higher paid employees from taking on more skin in the game. But some recent reforms like health savings accounts and the tax on Cadillac plans is pushing down that distortion, creating more room. The IRS actually has a policy that prohibits discrimination by compensation levels, but it's designed not to protect higher paid employees, it's designed to protect lower paid employees. So I argue that would not be prohibitive to this proposal. In fact, could be argued to require it because the current flat cost-sharing maximums tend to discriminate against the poorer employees because it prevents them from taking advantage of those health insurance benefits to the same rate that the higher paid employees do. So there's actually potential here for the IRS rulemakers to nudge employers in this direction. There's also potentially an agency problem that the wealthier employees are setting healthcare policies for the firm and may, in the short run, prefer non-scaled benefits if they don't think that they can cash out the savings and wages instead. So the other solution to the split benefit, I'm going to set that aside for today, but it ultimately involves paying people cash on the possibility that they will decline to consume. Say, here's a portion of your health insurance. If you want to consume this expensive unproven care, take the money and pay for it, and we'll pay the remainder. We'll sort of match it. For a lot of people, that when I've presented this idea, strikes them as viscerally quite wrong, paying people not to consume health care. And that's essentially what a cost sharing does too. If we increase cost sharing on wealthier people, you're saying you have to spend your own money if you want health care. And so the big objection that I want to develop in the Tulsa Law Review paper is this question: is it wrong to use incentives to discourage consumption while nonetheless preserving choice? And that really, it's only plausibly true, even if we ignore society's interests, it's only plausibly true if the healthcare consumption would be good for the patient. It would actually be something that would improve their well-being. But as a policymaker, we actually don't know whether any individual healthcare consumption would be good for the patient. Professor Elhaig, I'll just one final quote from his in this 1994 article, says, "Paternalism perhaps most accurately explain what actually motivates policymakers to refuse to simply redistribute cash. The poor, many believe, would irrationally spend money on the wrong things." And that's the main objection I get to these sorts of proposals, is that if you put skin in the game, people will stop consuming. You're actually paying them to be sick. And so I want to take that head on in this paper and develop really 7 reasons why we might not suppose that health care consumption is in a patient's individual interest, unless we have specific, credible evidence that it is. And the first is the physician's conflicts of interest. Physicians are in fee-for-service relationships, they have relationships with industry, they're often self-referrers, and I've reviewed the evidence here and shown that in another paper and shown that these relationships actually seem to bias their prescribing behavior. So the mere evidence that we have a prescription is subject to question. We also know from I've already shown you that most care prescriptions in the United States are not supported by evidence. There have been no randomized studies to show that they work. When based on the evidence, we also know that it's often false. A review of all the articles published in the New England Journal of Medicine, for example, for the last 10 years, that checked whether the article proved a previous clinical practice or disproved the previous clinical practice, found that about half the time the new articles were disproving prior clinical practices. Things we thought that worked were discovered in the New England Journal of Medicine that actually didn't work. That's a review of every article published, just one example of how the evidence can be false. In the United States, about 80% of the clinical trials of drugs and devices are funded by the drug and device industry themselves, and those studies have been shown to be 7 times more likely to produce favorable results. So even when we think we know that something works, we sometimes later find that it doesn't. There are also rampant publication biases. Journals are much more likely to publish an article if it shows that something works. At the same time, that buries a lot of articles that show that it doesn't work. There's also been a very large difficulty in replicating prior research. There's a systematic problem. Even when we have true evidence that something works, the effect is often quite marginal, meaning that we've proven that a statistically significant number of patients get better, but often that'll be as small as 1 in 100 patients that take the drug. And often in the realm of 1 in 200 or 300 patients are there very serious side effects. So the benefit for any individual patient is like rolling a 100-sided die and hoping that patient is the one that on the margin gets better. In the future, through genotyping of medicine, we might get better at predicting whether you will be the patient that benefit from this drug, but at this point, it's largely, it seems to be luck. Finally, I mean not finally, but getting closer, nobody's really paying attention to cost in these high consumption ranges, so we can't really infer from the consumption decision that this will increase the marginal utility to the patient because of the moral hazard problem I suggested. And then, as we already heard, that other spending can promote health too. There might be other ways for the patient to promote their own well-being. So maybe we should defer to them if they do if they do choose to spend money elsewise. And finally, as we suggested, that other goals may trump health. We may value other things. So all these together, I'd suggest basically a presumption against consumption. That if an individual chooses to consume otherwise, and we give them the option, they choose to spend their money in a different way, we should probably reject that choice, unless we should probably not reject that decision or assume that they've somehow failed simply because they've declined health care. Thank you very much.
Thank you so much, Professor Robertson. It's now my pleasure to introduce Professor Abigail Moncrieff. She's the Peter Paul Career Development Professor at Boston University School of Law. She earned her BA cum laude from Wellesley College, after which she took a Fulbright Fellowship to Geneva to study comparative healthcare systems. She earned her JD with honors from the University of Chicago Law School, after which she clerked for the Ninth Circuit before serving as a gubernatorial appointee for the Health Information Technology Council for the state of Massachusetts, and then teaching and serving in her current position. Professor Moncrieff focuses her scholarly work on structural government barriers to efficiency in healthcare payments and delivery, as well as writing more broadly on structural constitutional law. So like Professor L. Haig, her interests in writing are actually quite broad in scope. Professor Moncrieff has published articles on both federalism and separation of powers, publishing on the major questions exceptions to Chevron deference and administrative law review. I see all of the law students cringe when they hear that. On healthcare federalism and separation of powers in the Boston University Law Review, and on federalism issues in medical malpractice, and more broadly proposing a concept of federalization snowballs in the Columbia Law Review, for which I know she credits Professor L. Haig's mentorship. So please join me in welcoming Professor Moncrieff.
Thank you so much, Sam, and everybody for having me. Just for the record, I grew up in Dallas, so Oklahoma is not so much a flyover state as like a state. But now I'm very happily installed in Massachusetts, so less of the rivalry now. I wanted to actually, before I get to my own presentation, which probably won't take the full half hour, just say a couple of words in response to Chris's presentation. So one thing that I find really interesting about the split benefit idea is that it's essentially what a lot of car insurance does, right? Like they just give you cash to repair your car if you want to, but in most states you're not required to actually repair your car. And so you can drive around with a ding in your door and take the money as compensation for the reduced value in your car. And we don't think that's a problem. So why is it that there's this instinct to think that it is a problem for healthcare, that consumers are not good enough at deciding whether it's okay with them to walk around with a ding in their door, as it were? And I think that part of the reason is that because so much of healthcare doesn't have an evidence basis, we don't trust ourselves to know what healthcare is good for us or not, because nobody knows what healthcare is good for us or not. And so we don't think that the consumer can make a rational choice between the ding in the door and fixing the ding in the door, because we don't really know how much money it's worth or how much harm it's going to cause to not cure a particular problem, or at least not try to cure a particular problem that we're having in the medical context. And so I think it's an interesting idea to say, well, why don't we just give the consumer cash and let the consumer decide? But you have to have a fairly strong libertarian prior to think that that's a good model for healthcare, and to think that, well, that consumer, if he or she makes the wrong choice and ends up going from having a relatively minor healthcare complaint to having a really big healthcare problem because we didn't nip it in the bud because we were not sure whether or not we needed to, then that's okay, and we're just going to have to maybe let that person, well, if we don't want to escalate healthcare costs because of that, we might end up needing to let that person go without healthcare down the road too. I think there's more complexity there than Chris's paper indicates, but I do think that it's a really fascinating idea to sort of play around with, and I look forward to reading the responses to objections in the Symposium piece. It's also a bit related to what I want to say here, although the PowerPoint doesn't deal with the part of what I'm going to say that relates to Chris's thing. So maybe I'll just tack on at the end if I have time. So Einer's most recent book was this incredibly impressive, very quickly put together series of articles that he had written for The Atlantic and National Review Online and various other sort of more popular online sources of arguments in favor of the constitutionality of the individual mandate, which, by the way, Einer opposed as a matter of policy. But as a matter of constitutional law, he thought was totally fine. So he writes this series of articles and combines them together into a book, making a journalist defense of the individual mandate. And by the way, Einer's also not so much an originalist in most of his constitutional thinking, I don't think, right? Maybe a little bit? Okay. I don't think of you as an originalist, but I suppose that, okay. So he writes this originalist defense of the individual mandate and puts it all together in a book. And here's the originalist research that he put together. So he says, he goes into the history from the late 18th and early 19th centuries and says, look, in 1790s and 1800s, we had purchase mandates. We had mandates for individual purchases of medical insurance and hospitalization benefits for seamen. Medical insurance benefits were required to be paid for by vessel owners, and hospital benefits the individual seamen themselves had to purchase. There was also a requirement that all able-bodied men buy and own guns. Amendment on steroids. Federally required. And Einer says this history demonstrates that the framers thought that individual mandates were, quote-unquote, proper exercises of national power. That's in quotes because it's a significant constitutional term, right? The necessary and proper clause says that the federal government is allowed to pass any kind of law that's necessary or proper to the execution of enumerated federal powers. And Einer says, well, the health insurance mandate helps to regulate commerce in health insurance and in health care. And the only objection to it is that it is improper to force individuals to purchase a product, to enter into a contract. Einer says framers didn't think so. The framers passed these three individual mandates, and so it must be a proper exercise of federal power. The opponents to the individual mandate come back with the following, which was all not very compelling. So they say that these things were passed under maritime law or the militia power, not under the commerce power. They say that the mandates for medical insurance were enforced through a duty, which was through taxation, not regulation. And they say that the subjects of the prior insurance mandates were already active in commerce because they were seamen. So they had done something actively to put themselves into commerce that they could choose to undo by leaving their jobs, and that the mandates were therefore more limited because they applied to people who were already active. So Einer writes back. The book is fascinating. It's this dialogue between him and his opponents. And he says, maritime law was the commerce power. That's what that was at the time. There was also a separate power to alter common law maritime decisions by the courts, but that wasn't what this health insurance mandate was. It was done under the commerce power. He says that the distinction about whether the seamen had been active in commerce or not doesn't matter because everybody in the United States is active in healthcare commerce at one time or another, and that's directly related to health insurance. So we can say that everybody who's subject to the Obamacare mandate is also active in commerce, the same as the seamen. And if you don't need a connection between the active commercial activity, awesome, between the commercial activity and the mandate, then you can say that everybody subject to the Obamacare mandate also is active in commerce by earning income, because the health insurance mandate in Obamacare doesn't apply to people who don't make income. It's enforced solely through income taxation. So the conclusion of the debate and the conclusion that Einer reaches in response to all of his, at the end of all of this dialogue, he says the individual mandate is not novel, contrary to the opponents of the individual mandate's assertions, and something the framers had no trouble seeing as proper for constitutional purposes, and it is just as related to interstate commerce as the versions from the founding era, as the health insurance mandates from the founding era. And then this sort of stunning admission from Randy Barnett, the intellectual architect of the challenge to Obamacare's constitutionality. And he eventually writes, I never rested the individual insurance mandate was unconstitutional in the original meaning of the Constitution, and neither did the parties to the lawsuit. So Randy Barnett, this scholar who put together the challenge to the individual mandate, and who also wrote a scathing critique of Scalia for being not sufficiently originalist, says, I wasn't being originalist in this particular argument. That wasn't ever my point. So Einer manages to draw out this big admission from Barnett, and it looks like Einer's got the better end of originalism on this particular argument. So then Obamacare goes to trial, and what happens? The government's lawyers, including the Solicitor General, Donald Verrilli, just didn't make this argument. They just didn't present it. They didn't talk about the founding era mandates. Then the conservative justices, including the self-proclaimed originalists Justice Scalia and Thomas, held that the mandate is unconstitutional. It's not a constitutional exercise of the Commerce power, in part because it's novel and not proper. And Chief Justice Robertson's opinion rests its Commerce Clause analysis on inactivity of the mandate subjects, saying they're not active in commerce, you can't force them to be active in commerce in health insurance. But then inconsistently, he says it's constitutional under the taxing power, and as part of his analysis there, he says that it's okay because it's limited in application to those with income, who, as Einer has said, are engaged in commerce. So Einer has this great argument defending the individual mandate on originalist grounds, and nobody picked it up in the Supreme Court, despite the fact that it was easily accessible online and other places. So what happened? So maybe Einer's argument was too distant and discontinuous, meaning that the founding era mandates had been passed and enforced in the 1790s and early 1800s, but then had gone away and hadn't been present in the United States in between the founding era and today. So maybe they didn't count because they were there at the founding era, but it's not like Congress regularly used that power in between. Maybe those mandates were just too narrow because they only applied to ship owners and seamen, and maybe the real objection was this mandate is bad because it applies to basically everybody in the United States. Exceptions for people who make too little money, but there's no way that you can get out of the mandate except by quitting your job and becoming poor and earning less income than the cap, whereas seamen at the founding era could potentially go get a different job that still makes the same amount of money. They don't have to put themselves into poverty in order to escape the health insurance mandate of that time. So maybe you could distinguish it on those grounds. But then there are other hypotheses too that might explain why Einer's argument didn't get picked up. One is maybe just the justices are unprincipled. Maybe they claim to be originalists, but they actually don't care about the original meaning of the Constitution. Maybe they were completely just confused and befuddled by the activity versus inactivity distinction. They just thought, well, these people are not active in the health insurance market, and you have to be active in the health insurance market first before you can have a health insurance mandate applied, and it doesn't matter that they're active somewhere else. Or maybe they think that we're not active elsewhere in commerce because I don't know, making income doesn't count as being active in commerce. Maybe the government lawyers just didn't know about this particular argument and they screwed up by not including it. Maybe we had, in the October term 2012, unusually stupid or rogue clerks for the justices. Maybe Scalia and Thomas really wanted this argument there, but the clerks were like, eh, and didn't put it in. Or maybe there were political constraints on the justices. Maybe the justices couldn't use this argument for some reason because they thought that Americans wouldn't like it. So we'll look at each of the hypotheses and try to decide which one makes the most sense. So the first one, that the original statutes were too distant or discontinuous to count, shouldn't matter to originalists. Originalism, if sincere, doesn't make space for the narrowness, distance, or discontinuity. If Einer is right that these mandates existed at the founding era, that gives us pretty compelling evidence as to the original public meaning of the word proper, which supposedly is what originalists care about, the original public meaning at the time of the founding, and shows that the original thinkers about the Constitution thought that mandating purchases was a proper exercise of federal power. So it shouldn't matter that these statutes are all really old and that Congress hasn't done the same things throughout history. On the second one, that the justices are just unprincipled, Chief Justice Roberts ultimately upheld the mandate, so he at least was not unprincipled. He wasn't just trying to get rid of a statute he didn't like out of, we can't use a pure judicial realism type of argument to say that that's why Einer's argument failed, because Roberts ultimately upheld the mandate and allowed the statute to go forward. And the activity and activity distinction likewise didn't matter to Roberts' taxing analysis, so again, you can't just say that he got completely befuddled by this activity and activity distinction. On the idea that the government lawyers maybe just didn't know about this argument, maybe failed to present it out of weird constraints, I have a good, reliable, off-the-record source telling me that the Solicitor General knew about this argument and did not feel that it was a good argument to present, and so made a choice not to present this particular argument. And he also said, the source also said that he didn't feel politically constrained himself to not present this argument, that wasn't part of his logic, so he just thought that it wasn't going to win. Were there stupid rogue Supreme Court clerks? Probably not. Pretty hard to become a Supreme Court clerk. So then, where does popular constitutionalism come in? The idea that I think is most likely to be the reason that this argument didn't make it to the Supreme Court and didn't make it into the justices' opinions is that current political preference mattered to the Supreme Court justices. So the Solicitor General and his team looked at what they thought, measured what they thought the Supreme Court justices were likely to think was a compelling argument, and they thought, well, this originalist research isn't going to get us anywhere because the Supreme Court justices just can't hold that Congress has the power to mandate purchases of anything under the sun. The Supreme Court of the United States can't be seen to hold that Congress has an unlimited power to mandate purchases, which is essentially what Einer's argument was, that if you look at the original public meaning, purchase mandate is a proper exercise of federal power. What does that imply? Yes, the federal government can mandate purchases of broccoli. It won't, because mandating purchases of broccoli is stupid, and Congress isn't that stupid. It's close, but not that stupid. And so there are political constraints that will matter to Congress too, but ultimately, yeah, Congress has the power to mandate purchases, at least as applied to anybody active in commerce, currently active in commerce, which is anybody making income. So the problem was that the justices didn't want to hold that because they didn't want to scare us and make us think that they were not that they were not going to be good guardians of our liberty. So we have good reason to think that that's right? This was a moment in history when the Tea Party was making a lot of noise about limits on congressional power and libertarian constraints on congressional power, trying to push for greater protection of economic liberty, and they were getting some traction, and the polls were showing that a lot of people did not support Obamacare, and in particular were opposed to the individual mandate. Interestingly, this didn't seem to apply to the taxing power, perversely, because the Tea Party types already think the taxing power is expansive and evil. So holding that the taxing power allows the individual mandate is not as risky in terms of ticking people off, and the Tea Party types really upset as holding that Congress has a regulatory power to force individual mandates. So the hypothesis that seems to make the most sense, given what we know, is that the justices were attuned to today's political preferences and were unwilling to hold that Congress had this expansive power to mandate purchases. The surprising part of that, though, the really surprising part of that, is that popular constitutionalism mattered more to the originalist justices more than their professed commitment to originalism. So if there's anything that's the opposite of originalism, it's popular constitutionalism, right? Caring about today's sense of what the Constitution means. So what can we take from that? What can we take from that sort of surprising conclusion that the justices cared about the Tea Party push for or against individual mandates? So one possibility is that popular constitutionalism is just more powerful than most of us give it credit for, that the justices care more than we thought about what we currently think about the meaning of the Constitution. One possibility is that popular constitutionalism itself is not all that powerful, but that other constitutional theories are also not that powerful and are less powerful than popular constitutionalism. So if the justices have a good textual or other kind of doctrinal reason to make a decision one way or the other, maybe that would trump popular constitutionalism, but other sort of theories of like originalism about how the Constitution should be read will take a back seat to a really strong popular constitutionalist movement. One possibility, which I didn't put on here but should have, is that this particular popular constitutionalism movement was just really, really, really powerful. It's the last one. It's right there. Obamacare was just fluky in its degree of unpopularity. People just really, really hated Obamacare. And then one possibility is that originalism is just uniquely weak as a constitutional theory, that it will always take a backseat to something else that could trump it. Justice Scalia has sort of admitted this by calling himself a faint-hearted originalist, but Randy Barnett, who was the one to sort of cave immediately to Einer's research, is the one who wrote this scathing critique of Scalia's infidelity to originalism. So he really has no excuse for dumping on his originalist roots once he saw the unpopularity of Obamacare. So this is just kind of this fascinating examination of what happens when we have really strong political preferences one way or another, and a really strong originalist argument, and we got Einer in dialogue with the justices, with originalists, and the solid originalist argument in favor of the individual mandate just lost. And not only did it lose, I should say, the justices sort of skated around it and pretended that it was wrong without actually rebutting it. They were like, they got up and said, this is a novel exercise of congressional power, despite the fact that it clearly was not. So it was just a really interesting story, and I don't have a solid conclusion about what we can glean from it other than just, this was a weird little case. This was a weird, very big case. And very weird, very big case. And maybe originalism is not as strong of a commitment as one might have thought of the conservative justice movement. That's it.
Thank you so much, Professor Robertson and Professor Moncrieff, sort of speaking on two aspects of healthcare reform that sort of fall within the sort of wide canvas of Professor Elhaeg's writing, so constitutional issues, as well as simply rational choice. Exercising moderator's privilege, I'll go ahead and ask the first question aimed at Professor Robertson, and then I'll open up the floor and I'll just sort of keep a cue or make sure you raise your hand high enough so that I can see them. And Professor Robertson, I really have a sort of two-part question. And the first one, I intend to be provocative. I don't mean it to be taken as a representative of my sort of broader ethical views, but it seems like the elephant in the room behind your proposal is age. All right. So when we talk about consumption, and we worry about consumption, and even behind the data that you use, there's a massive system of redistribution from the young to the old in terms of when healthcare is consumed. So in the last 5 years of life, you have an extraordinarily intense focus of costs and consumption. It is also the time that arguably that consumers are the least sensitive to all of the sort of decisions that you hope to structure through your proposal. And it really begs the question of, at what point does expensive, life-saving technology stop producing a good for the patient, not in the patient's eyes, but in society's eyes? And that sounds ghoulish. It asks us to make really hard questions. And it also sort of makes us focus on those consumers who are covered by Medicare. And if a lot of those consumers are covered by Medicare, as I suspect that they are, how much does your proposal really do for us? And your answer may be, it's not my problem. Nobody in Washington, D.C. wants to talk about that. I don't either. Fair enough. Leads me to my second question, which is, talk a little bit in your paper about the distorting effects of the Affordable Care Act. And you seem to be attentive to at least one distortion, which is some workers, if they are in fact empowered by the availability of the state or the federal exchanges, may, as you suggest, ask for additional wages or ask for cash or maybe even a pair of pants, knowing that they can go to the exchanges and get covered there. But we can't predict, to say nothing of employers that will just opt to pay the penalty if they believe that current and future expenditures are going to be too large. But we can't predict how that might generate a system of adverse selection, where in fact low-wage workers, who often are younger workers as well, just seek lower premiums and higher cost shares, thus undermining what I think is ultimately a very sound and intriguing proposal.
Just to hear, probably so.
You know, these should work.
Great.
So I think everybody will be able to hear you.
Thanks so much for your questions. So both of these models I've primarily developed as market-based solutions and haven't focused on Medicare, but it obviously begs the question of whether some of these reforms could be used in that domain. And in the laboratory experiments we did with this concept using mock patients and vignette-based studies, we actually asked them if they'd support use of this proposal in Medicare, and surprisingly found that widespread support of using a split benefit in Medicare. And it didn't seem to polarize along party lines, which surprised us. But, you know, towards the end of life, I think individuals make a lot of financial decisions and have a lot of sort of alternative spending priorities. And you see this when they're thinking about estate planning. And often you'll have, a couple going into the older age together. And so people do have posthumous priorities for spending and might well prefer to leave a legacy rather than spending on healthcare alone. So it does sort of complicate the question. Think about how much healthcare spending is at the end of life and how much of it is then funneled through government spending and Medicare. Those two factors are confounded at that point. But I think it doesn't necessarily change the ultimate economic analysis if we suppose that those people still might have an opportunity cost, might have other things they'd rather do with money than spend on cancer drugs, for example, that are prescribed off-label, and literally even on-label. They've been defined by proxy endpoints, by tumor growth rates, for example, that have not actually been correlated to even a single day of extended life. And so sometimes we will spend $80,000 on a prescription that's literally not proven to extend life by a single day. And so at that point, and when you think about the side effects of some of these drugs as well, it's a reasonable choice to choose hospice instead, even taking the money off the table. But we sure shouldn't have a system that biases people towards consuming this expensive care. And so I'd be willing to sort of bite some bullets even in that domain and suggest that it is generalizable. One of the, on your second question about the distorting effects of the Affordable Care Act, one problem with the status quo is we actually do have some scaling of cost-sharing obligations in the exchanges. I didn't have time to mention this, but the Affordable Care Act actually lowers cost-sharing obligations in a scalar way, actually in a tiered way, for people with lower income. Forcing the insurers and using tax credits to help reduce those burdens. But since we don't have scaling in employer-sponsored health insurance right now, it really sharpens the adverse selection problem that creates an incentive for lower-paid workers to leave the employer and go instead into the exchanges where they can get that subsidy. So I think it's a pretty big problem now that I'm not sure people have really thought about that point in particular very much. There's one paper that's developed the point. So that, I think, is a second reason that we need to move towards, if we want to maintain the employer-sponsored system, which is really a premise of the Affordable Care Act, that will continue having most people insured by employers. I think scaling cost sharing within the employer realm will help reduce that distortion. We shouldn't use that as a factor that drives people to the exchanges. That's sort of an artificial distortion in the market. And so I think we could actually use the anti-discrimination provision that's already been written into the tax code. The IRS could use it somewhat aggressively, actually, to nudge employers towards using scaling within. I didn't get to the entire breadth of your question, but I also don't want to monopolize.
No, perfect. Mr. Kern?
On the one hand, you start your presentation with this idea that healthcare is something that government should be sort of morally obligated to provide as a right to people, and then a lot of your presentation was dedicated to this idea of sort of a market-based approach. And for policy reasons, sort of the moral argument suggests that maybe government should be involved in regulating the actual cost of healthcare at the point where a person uses it, or even providing a single-payer system. The market-based approach has emphasis on kind of rationers as people that have skin in the game, and healthcare is a good. Can the moral thesis and the market thesis play well together for policy reasons, or do we have to kind of pick one over the other because they're mutually exclusive as matters of policy?
Well, that's a great question, and what we've ended up with in the United States is this mixed solution where we try to do managed competition. We prop up these exchanges and define standardized plans, and then try to get insurers to compete just on price rather than competing on manipulating the backdoor plans terms and things. And so the idea is that if with the right, subsidies, for example, in the exchanges, the ones I just referred to, we can allow a market to achieve the moral imperative that Professor Elhaeg defined in that quote in the beginning. So that's the premise. It sort of remains to be seen whether it can work. There are other countries that have done versions of this, but none exactly like this experiment that we're now trying. So, one of the motivations for my reform is that the market solution isn't going to achieve that. It imposes on poorer workers a cost share that's 30% or 40% of their income in a given year. They won't have access to that middle class care because they don't have the same degree of skin in the game as a proportion of their income. So, I think there's a sort of market failure for achieving this moral end, which can be reformed through more precise regulation that that requires employers or nudges employers or removes obstacles for employers to approach scaled cost sharing. So I remain sort of, at least at a certain level, committed to with enough tinkering, we can make this system work to roughly achieve the moral end, even through a regulated competition.
Thank you.
Yes. My name's Sandra Alexander. I'm an attorney in private practice here in Tulsa, but more importantly, I am a board member of the Hillcrest Medical Center, which is the hospital that is a mile and a half from here for the last 20 years. And at this particular point in time, I'm also chairman of the board. And Professor Robertson, I listened to your entire presentation. And I'm going to challenge you on it because you have forgotten one specific side of the commercial transaction involving healthcare, and that's the provider side. At no time during your presentation did you ever mention anything with regard to provider behavior or provider choices. You're speaking in terms of the consumer and of insurance. But there needs to be a recognition that an individual may have insurance, but there may be no one who wishes to sell to them for the price that is specified. And the choices that are being made with regard to providers in this environment that's being created by these healthcare policy choices is going to lead to a set of circumstances where people may be spending money for health insurance, but they cannot get health care because the provider is unwilling to sell for the price specified. And I think further analysis needs to take into consideration provider behavior and the choices that providers are now making in light of the environment that's being created.
Excellent points. I mean, there's a whole other side of this beyond what I was able to talk about today. I mean, I just mentioned providers in passing to mention the conflicts of interest, the financial incentives that sometimes are not aligned with patient care. And I think what you're implicitly referring to is a problem of cost control. When you have sort of a non-market-based regulator putting a cap on prices, I mean, this is a classic problem we've seen for centuries. That when you do cap prices, you sometimes will have insufficient insufficient supply to meet the demand at that lower price. So, this is a complex market. So if we're talking about insurers setting reimbursement rates too low so that you end up not having access to care, the market solution is supposed to be that the employer who bought that insurance suffers when their employees complain. You bought me this benefit, but I can't actually monetize it. I can't actually get the care that you're supposedly providing. I'm therefore going to pressure my employer to put pressure on the insurer to raise reimbursements and increase the size of the provider group. Likewise, when Medicare or Medicaid is reimbursing too low, there's supposed to be political pressures. But the problem is we don't always have political accountability, especially in the Medicaid population, for them to be able to call up a congressman or a state administrator to get them to be responsive. So there's sort of real difficulties in that area when the market breaks down or the political economy breaks down.
In this community, we have providers, especially physicians, who are refusing to take Medicare patients because the reimbursements. I mean, essentially what occurs, each and every month, I'm looking at balance sheet. And we've got to sell product at a certain price in order to generate a certain revenue. And healthcare is a first-come, first-served basis, okay? So I can easily turn down someone who's not going to give me the revenue that I need because there's somebody else in line. And that's the kind of provider behavior that is also developing. You're also looking at the instance where there's concern with regard to people going into bankruptcy because they can't pay their share of the bill. The behavior that's being developed on the provider side is I'm not going to accept the 80%, the 60%, or the 40% until I get the consumer share. So I'm going to refuse to provide them any care until they pay their share of the bill. And therefore, you're going to see the drop of bankruptcies because there won't be that discrepancy that will take place. The consumer just won't get the care.
Sometimes we're seeing, secondary credit markets arising in these areas where there are people can use a regular credit card to pay for care and then end up finding themselves in bankruptcy. We see a lot of people refinancing their houses. If the real estate market will support, they'll refinance their houses, take equity out, pay for medical care. And there's also a whole new breed of medical credit cards. But whether any individual has access and whether that's a rational choice is a difficult question.
Yeah, and see, when you do that, that's not my problem. I've gotten my money in my balance sheet.
Professor Rao, I think you're next.
So I think I may have the last question, so I'll conclude with a question for Abigail, and I think it's a fun question. Do you think that the ACA decision is an N of one, or is it representative of any larger pattern? And then perhaps a separate question, but do you think it's going to have effects on originalist thinking going forward, given that perhaps originalist thinking was explicitly rejected by the originalists in this case?
So as far as whether it's an N of one in terms of popular constitutionalism, the answer is clearly no, right? We have other cases in history that I think can be identified as popular constitutionalist cases, and even those cases that came out in favor of a popular constitutionalist movement instead of following what the justices would themselves prefer to hold if they were abiding by their professed principles about constitutional meaning. So it's an N of very few, but it's not necessarily an N of one, I don't think. As far as whether it'll have an impact on originalism, I kind of think not, because they all just went like this to Einer, right? Like they all just were like, no, there were no mandates at the time of the founding. This is novel. and kept asserting over and over again, this is a novel exercise of congressional power. And it was, they were just completely disingenuous about it. So I'm not sure.
Like they are in every case.
Well, I mean, are there any originalists who are upset with them for disregarding originalism?
Not that I know of. I mean,
Okay.
when Randy comes out and says, you know, I didn't mean for this to be an originalist case, this one's not, you know, and he's just like, I'm comfortable with that, this one's not, the rest of them are. You know, I think they're just going to keep going with this.
I know originalism when I see it, right?
Right, exactly. I know
Okay.
I know a case that should be decided by originalism when I see it. It's the one that I agree with when originalism is applied.
All right, well, thank you both again for your presentations. I think we're resuming at 10:30, is that right? There's coffee and snacks outside. Please join me in giving one last round.